Hey everybody, we are back in the shanty. It's been a while. It's been a while because it was the holidays, and it's been a while because I have shanty recording block. Okay, it's been a while. So I want to talk today about a subject that I've been thinking about doing something about for a while, but I've had a hard time figuring out how to do it because I don't want to do it in a way that offends anybody. And I've been figuring out how to try to frame this in the right way. The Philadelphia Flyers helped me do that. About 5 days ago, the Philadelphia Flyers had what they called an annual Pride Night celebration. And during the Pride Night celebration, they wore, during the warm-up, pregame warm-up, they wore rainbow jerseys and used sticks taped with rainbow tape. One of their players refused to participate, did not participate. I shouldn't say refused. Did not participate in the pregame warm-up. He did play in the game, but he didn't participate in the pregame warm-up. And his absence was conspicuous, at least conspicuous enough that a reporter noticed it and asked him about it in the postgame interview. Now, this is what he said. First of all, he said that the reason he didn't participate was because his religious faith precluded him from doing it. He's Russian Orthodox. I don't know anything about the Russian Orthodox Church, so I can't speak to that. All I know is that's what he said. Here's what he said, quote, in the interview, which I watched, which was very measured and calm. Quote, I respect everybody. I respect everybody's choices. My choice is to stay true to myself and my religion. That's all I'm going to say, end quote. Again, very calm, very measured, very laid back. He did get a little testy at a reporter who followed up. He said, look, that's all I'm going to say. Didn't you just hear me say something like that? Can't you respect that? The team supported his decision, and the coach supported his decision in the postgame press conference, said he's being true to himself and his religion. That's what I love about Provy. Have you ever noticed how hockey players are all, it's not Provorov, it's Provy, it's not, I don't know, Smith, it's Smithy, it's, anyway. So the team supported him. And that was it, right? He played the game. On goes the season. Except, of course, that's not it. Because we have what I believe is both the best and worst invention of all time, the internet. And the internet went nuts. And now Provorov is either a villain, depending on what side of the aisle you're on, or he's a hero, depending on what side of the aisle you're on. And, of course, this has become a political issue and blah, blah, blah. And it's none of those things. For us, here's what it is. First of all, you're going to see that you're going to have a guy that refuses to wear a hockey sweater. I don't know why they call them sweaters, by the way. They're not knit, but a hockey sweater. But you are going to be faced with an issue at some point where you have a clash between these two particular rights that seem to clash on a regular basis. LGBTQ rights and religious rights. Now, what's interesting about this to me from an employer's perspective, from an HR's perspective, is these rights come from the exact same place. They come out of the same statute, right? Where do the rights come from? The Constitution, right? No, that's wrong. You know it's wrong. You know it's wrong if you listened to me before. The Constitution does protect your right to religious freedom, but only with respect to the government and their behavior toward you, not with respect to your individual employer's behavior toward you. We've said this over and over and over again. The Constitution does not govern the relationship that you have with your individual employees as an employer. Comes from a statute. The statute, in this case, is Title VII of the Civil Rights Act of 1964. And Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of a number of things, including in that list, religion and sex. Now, does sex mean sexual orientation and gender identity? Yes, it does. Why do we know it does? Because the Supreme Court of the United States, in a case called Bostic versus Clayton County, Georgia, just as recently as 2020, said it did. What about state law? Elliot Larson doesn't say sexual orientation or gender identity either. But there is currently a bill pending before the legislature that would include those two terms in the protections afforded by Elliot Larson's Civil Rights Act. So you've got a protection for these two different groups of people that appear to be unable to get together, and it just clashes and clashes and clashes. So what do? Do we have a guidepost anywhere. Which one takes precedent? Or does neither of them take precedent? And how do you, as an HR person, balance this? Well, we do have some guidance. Now, the guidance we have for religious accommodation is considerably better than the guidance we have for not discriminating against members of the LGBTQ community. That's not because one is more important than the other. It's because we've been having these conversations about religion longer than we've been having these conversations about the LGBTQ community. Remember, until 2020, theoretically, you could discriminate against a member of the LGBTQ community in work, and it wasn't a violation of Title VII, at least. It might have been a violation of your state law. So how do we balance these two things? Well, let me give you two examples. There are cases, one out of the Ninth Circuit and one out of a district court in Colorado. They are both from back in 2004, and they both involved Christian employees objecting to either diversity initiatives or diversity programs, okay? The first is a case called Peterson versus Hewlett-Packard Company, and the second, that's the Ninth Circuit case. And the second is a case called Bonanno versus AT&T Broadband. And interestingly enough, the decisions came out exactly opposite. In Peterson, the company won. And in Bonanno, the company lost. Now, let me tell you why. Let me tell you what happened, and then I'll tell you why. So in Peterson, Hewlett-Packard was having a diversity training initiative, and they put posters up around the workplace, and those posters depicted a gay couple on the poster. Peterson objected to that. So instead of complaining to management or talking to management about it, he went back to his cubicle and he put up a bunch of posters of his own. And those posters contained anti-homosexual sentiments, claiming that homosexuality was sinful and quoting Bible verses, claiming to quote Bible verses. He was asked to remove those posters, and he refused. So he was fired, and he sued. And one of the things he claimed in his lawsuit was that Hewlett-Packard failed to accommodate his sincerely held religious beliefs, and he lost. Then we have Bonanno versus AT&T Broadband. Now, Bonanno involved a situation where Bonanno refused to sign an employee handbook acknowledgement because the employee handbook acknowledgement, at least in Bonanno's reading, required him to, quote unquote, respect and value individual differences. All right? And he said, I can't respect and value behavior that I believe is sinful. He said this. He said, look, I'm not going to discriminate against people that are in the LGBT community. I would never do that. And I'm not going to harass people that are in the LGBT community. I would not ever agree to that either. But what he did say was that valuing, if you will, this behavior conflicted with his religious beliefs, that he couldn't value the behavior without compromising those beliefs. In other words, according to the court, he said that he could not value, that is, hold in esteem or ascribe worth to such behavior or beliefs without compromising his own religious beliefs. Bonanno was also fired, also sued, and he won. He won $150,000. So what are the differences in these two things? Well, I think there's two differences. The first is this. Peterson, in the Hewlett-Packard case, took an affirmative action that not only expressed his point of view, but did so in a way that was offensive to other people. In other words, it affected other people. He put posters up in his cubicle that had things that some people would consider to be hateful, and that were, on their face, a violation of Hewlett-Packard's anti-harassment policy. And when he was asked to remove them, he refused. Okay? Bonanno, on the other hand, simply refused to sign a document that was going to go in his personnel file that no one would ever see. It had no hateful sayings on it. It had no controversial sayings on it. It had no sayings at all on it. He just didn't want to sign the handbook acknowledgement. So that's one difference. The second difference, and really the very, very big difference, in my opinion, is this. When Hewlett-Packard approached Peterson and said, hey, we want you to take these things down, and he refused, Hewlett-Packard actually talked to him, at least according to the court on 4 separate occasions, about how they could accommodate his religious beliefs, how they could make this all work. So when the court addressed the religious accommodation claim that Peterson made, they said the following. The only accommodations that Peterson was willing to accept would have imposed undue hardship upon Hewlett-Packard. In other words, the court acknowledged that Hewlett-Packard actually engaged in an interactive process, which, by the way, is not it isn't contained anywhere in Title VII. That's from the Americans with Disabilities Act, the interactive process. But it was important to the court here that they talked to Peterson. They tried to work out a compromise. They were unable to work out a compromise because he wouldn't agree to take the posters down. And as a result of that, they fired him. All right. In Bonanno, AT&T never spoke to Bonanno. They simply said, sign the acknowledgement. And he said, no. And then they said, okay, you're fired. The court said, had AT&T gathered more information about Bonanno's concerns before terminating his employment, it may have discovered that the perceived conflict between his belief and AT&T's policy was not an actual conflict at all, or that if a true conflict existed, it was possible to relieve that conflict with a reasonable accommodation. In other words, the court there also a different court in a different circuit, same year, dealing with roughly a similar issue, found that because the company didn't engage in the interactive process, the company was liable. Let's go back to the Flyers. What did the Flyers do? Okay, so first we have a situation in the Flyers that's like Bonanno. In other words, there was no hateful speech here. Provorov did not come out and condemn homosexuality. As a matter of fact, he said, I respect everybody and I respect everybody's choices. He simply said, I don't want to skate in the warm-up. Now, I don't know if the Flyers engaged in the interactive process with him or not. I don't know if the GM and the coach sat down with him and said, hey, how can we make this work? But here's what they did. They said to him, whether they said it to him actually with words or whether this is just the way it worked out, don't worry about it. You don't have to skate in the warm-up. You can still skate in the game. We're going to put our regular kit back on. You'll be able to skate in the game, and everything will be fine. In other words, they accommodated his sincerely held religious belief, which you're required to do. And they did it in a way that didn't hurt anybody, except maybe Provorov, who didn't get a chance to warm up. And as a result of that, I think the Flyers handled this exactly the right way. And the lesson for us is just that. The lesson for us from the Flyers and from Bonanno and from Peterson is when these issues occur, we cannot just sweep them under the rug, or we cannot assume that one side is correct and the other side is automatically wrong. We have to talk about them, all right? We have to discuss options. We have to engage in the interactive process. And doing that, even if you fire the employee, may in the long run protect you from that discrimination suit that might result from it. Hope this is helpful. It's good seeing you all again, and I'll see you next time.